ducky and her ducklings always seeking justice and truth. This ducky won't be silenced by the haters, seeking out the facts while providing the receipts. She is loud with her opinions in this cruel world of villains. This ducky will talk, give her sass, while still keeping her class. So join in the pond with the ducklings from all over the place.
Laura Owens is drowning in felonies right now. She is unable to keep her head above water with 7 more felonies coming down. She previously had 7 in regards to the Owens v. Eckerd matter. Now she has 7 additional ones, some being similar, some being completely separate in regards to the Owens v. Gillespie matter. Both Arizona cases, and so this is not going to have anything to do with Maricini. That is something that the California DA's office would have to think about and talk about. But today we're covering the additional 7 felonies in Laura Owens' criminal case. Let's get quacking. So this is kind of basically what we're going to be talking about, just an overview of what a lot of us woke up to or got around lunchtime or something. On November 6th, this was the news release by Maricopa County that Laura Owens indicted on additional felony charges, date of birth, related to false claims of pregnancy involving a second victim. In 2021, the victim began dating Owens, but after the 3rd date, he decided not to continue the relationship. Owens then claimed to be pregnant by him. Maricopa County Attorney's Office investigators found evidence that Owens falsified documents to bolster this claim. On Tuesday, which is not this past Tuesday, but before that, was indicted on following felony charges: 1 count of perjury, 1 count of fraud, schemes, and artifices, 2 counts of taking the identity of another, 2 counts of forgery, 1 count of theft by extortion - accuse of crime. These charges are in addition to those involving victim Clayton Eckerd. The Eckerd case is set for trial in January 2026. This is why I said we don't know if it is going to be 1 trial or 2 trials, and we'll learn about that later down the line. This was just the original one before the indictment actually came out, but we're going to go over the indictment in just a second. And remember that a criminal charge is merely an accusation, and the defendant is presumed innocent until and unless proven guilty. Well, that is going to be the case for Laura Owens still. I believe she's guilty. Now, if for some miracle somebody comes out and finally, out of the woodwork, that she could not produce in the Eckerd case or in Gillespie's case, this Los Angeles Planned Parenthood crap comes and says, yes, she actually did, then there is nothing that is going to save this woman. We have been covering this case for over 2 years, and there's just no evidence backing her story. So while the jury needs to look at it that way, us that have been following this case forever and know the evidence like the back of our hand, and who even brought it to Maricopa County, Rachel Mitchell's attention, that, all of us think she's guilty, but we had an open mind, and I still would have an open mind if something came out that proved that she wasn't lying about at least one of these pregnancies. Maybe she's innocent on one, or part of these crimes, and just lied about when she miscarried. I don't know. I don't believe she was ever pregnant with any of these. But that is my opinion, and the jury needs to come in there, and listen to all the evidence and keep an open mind, just like all of us did. Like, just kept waiting, and we are still waiting for Owens to show us something that validates any part of her story, and there just isn't anything. But stay with me as we go through the indictment and as we break down these statutes that she has violated, and we're also going to go over things that we know in the Gillespie case that go along with what she's being charged with, to kind of give an overview of everything that's going on as of now. Okay, so we have the new full indictment. Now, with this indictment, I do not know, as of looking at the docket, I do not see that they've like withdrawn the old indictment of the first seven charges from Clayton Echard's case against Owens. And then this. So I don't know if this is they like withdrew that pleading with, intention to refile this new one. So we still don't know if it is going to be one case of Owens v. Echard, or the Owens v. Echard type charges, and then the Owens v. Gillespie type charges. If they're going to be in two separate trials or if they are just going to be one, we will find that out later down the line. But if you haven't seen me break down the first seven charges in depth, I have done a video on it. I will link it in the description box down below. It will also be in the little eyelet at the top if you want to pause this one and go look at the first seven charges and see that video first and then come back and watch this one. You can, or you can watch this video and then go and watch that one if you haven't seen it, because in today's video, we're going to focus on counts 8 through 14, the seven newest charges against Laura Michelle Owens. But let's read through this indictment. So it is from our girl, Rachel Mitchell, Maricopa County attorney, and the deputy county attorney, Edward Leiter. He's the main one that has been on the case filings, that is probably going to be running this case, like one of the prosecutors, whereas Rachel Mitchell is the DA, or yeah, I believe she's the DA. And so she's kind of like the person that, does the press conferences and stuff like that. But Rachel Mitchell, she might make an appearance, but is not going to be the one prosecuting this case necessarily. Right now, Edward Leiter is the one that is doing that currently, along with, I'm sure, other prosecutors in the DA's office. So in the Superior Court of the State of Arizona, in and for the County of Maricopa. So Arizona versus Laura Michelle Owens. Indictment. Count 1, which these are the ones involving Clayton Echard, fraudulent schemes and artifices, a Class 2 felony. Count 2, forgery, a Class 4 felony. Count 3, 4, 5, 6 are all perjury, Class 4 felony. And then count 7, tampering with physical evidence, a Class 6 felony. So those are the 7 that involve Clayton Echard and Owens scheming in that case. Now, the new charges are now count 8, perjury, a Class 4 felony. Count 9, fraudulent schemes and artifices, a Class 2 felony. So those two are two that match Clayton Echard ones. Because as we talked about, some are identical to Clayton, because you can have one for each victim. Then we get to Count 10, taking the identity of another, a class 4 felony. Count 11, forgery, a class 4 felony. Count 12, theft by extort dash accuse of criminal, like a crime, a class 4 felony. Count 13, forgery, a class 4 felony. Count 14, taking the identity of another, a class 4 felony. So she has another count of perjury. So that makes it 1, 2, 3, 4, 5 perjury charges, which is something that isn't prosecuted very often because perjury is sometimes hard because just lying is not necessarily considered perjury. You have to knowingly tell a lie, and the prosecutors have to be able to prove that you knowingly lied and that it wasn't just a mistake or a misunderstanding or you worded it wrong or at the time that's what you thought or that's what you heard. Like you have to be able to prove that this person knowingly lied. And so it's just not something that you see. And I think if all they had on Owens was perjury, she would never be charged. I think it's because they have these other charges. And I think if Owens was willing to take a plea deal, if they ever offer one, they would drop the perjury charges, I believe. Because while no, you're not supposed to lie and everything is supposed to be under oath and it's made to a big deal, the truth is that it's just not something that is commonly prosecuted. Um, it takes a lot of court resources and stuff, and jails and prisons are already full, and do we really just want to put liars in jail? I think some should. I think the very worst should. I think Amber Heard should have been, um, especially in Australia. But here, because they were looking for other things, they are able to prove, or the prosecutors believe that they can prove beyond a reasonable doubt that when Laura Owens made certain statements at certain times to the court or in her documents and court filings under the penalty of perjury, that she knowingly perjured herself. And then, so then we have the fraudulent schemes one. So she has two of those now, one for Greg, one for Clayton. Oddly, we do not have tampering with physical evidence, but we have a forgery. But we also have taking the identity of another. So instead of maybe doing maybe she didn't do arts and crafts herself in the Greg Gillespie case like she did in the Clayton Echard case, she had other people do the arts and crafts, or she just stole an image and didn't make sure her name or anything like that was on it. And then we've known that she has taken the identity or assumed the identity of several people that we are suspicious of her actually being that person. And then theft by extort. To me, she also tried to extort Clayton, but because she never filed a lawsuit against him, then it's not necessarily a crime. She threatened to, she blackmailed him about it. And I think if she ever did try to, it would have been the thing. But at the same time, you could also say when she put in that parenting plan and child support thing against Clayton, wouldn't that be a way to try to extort him? Because that was for financial gain. And we know she's accused all these men of crimes that never happened. So let's get into the rest of it. The grand jurors of Maricopa County, Arizona, accused Laura Michelle Owens on November 4th, 2025, charging that in Maricopa County, Arizona, also November 4th, this is a day before she is supposed to be in California, in San Francisco, in front of Judge Gold for the DVRO renewal hearing, because that was on the 5th. Did she know about this indictment, or did her attorneys know, hey, this indictment's coming down. We're charging her with new stuff. And this is part of the reason she needed a medical emergency to be in the hospital emergency room. Is this if she was having certain ailments, which I do not believe because she was horse jumping. I didn't believe it before horse jumping. I don't believe it after it. But was this added stress of knowing about these indictments what pushed her over the edge, and her health and her stress over the edge to go to the hospital? Now, we don't know if she actually went to the hospital, if she actually had an emergency procedure where she was put under, like she said she was, or and whatnot. But it's interesting the timing, because this came out to us on November 6th, a day after the DVRO renewal hearing, and the Mike Maricini's DVRO has been dismissed. So it was like 2 days of celebration for JFC, but a bad week for Laura Owens. So count one, which, like I said, we've already gone over, but we'll go over this whole indictment just for those who don't remember or want a refresher. Laura Michelle Owens, on or between May 17, 2023 and June 10, 2024, pursuant to the scheme or artifice to defraud, knowingly did obtain a benefit from Clayton Eckerd by means of fraudulent pretenses, representation, promises, or material omissions in violation of ARS 132310, 13701, 13702, and 13801. Like I said, we're just going to go through the indictment. But if you want to hear me break down the different statutes that they're claiming and stuff here on these first 7 charges, you will need to go and look at the previous video. Count 2. Laura Owens, on or between June 27, 2023 and July 11, 2023, with intent to defraud, did falsely make, complete, or alter a written instrument, to wit, sonogram, in violation of ARS 13-2002, 13-2001, 13701, 13702, and 13801. Count 3. On or about October 25th, 2023, in regard to a material issue and believing it to be false, did make a false sworn statement, to wit, testifying in front of Judge Judy that she had not been intimate with anyone else since March 2022. And then she was in violation of statutes. So this one was interesting because they have proof that she has been intimate with somebody in the time that she's saying she was not intimate with anybody. So they have proof, I'm guessing off of her electronics and stuff, or talked to a person that says, yeah, I was intimate with her. Maybe even several guys that she was intimate with. Thankfully, they didn't become a headline, and that they got out, but maybe they were like, yeah, I'm not. But they were intimate with her, so they could have been in the same situation. This could have been them. Count 4, on or about March 1st, 2024, in regard to a material issue and believing to be false, did make a false sworn statement, to wit, claiming that sonogram image was hers during a sworn deposition in violation of certain statutes. Count 5, on or about March 1st, 2024, in regard to a material issue and believing it to be false, did make a false sworn statement, to wit, video clip of father touching pregnant belly in violation of these statutes. So those counts 4 and 5 are from the date of the deposition that she finally went to after skipping a previous one. This is when Corey Keith was Laura's attorney, which we love Corey Keith and we miss him. And he did the right thing in the Clayton Eckerd case by having candor with the court. So much respect for Corey Keith. He was bamboozled by Owens in the beginning as well. Count 6 on or about June 10th. So this is the day of the evidentiary hearing, or what people consider the trial in the Eckerd case, in regard to a material issue and believe it to be false, did make a false sworn statement, to wit, claiming that's me showing my pregnant stomach in violation of statutes. Count 7, on or about June 10th, with intent that it be used, introduced, rejected, or made unavailable in an official proceeding which was then pending, or which Laura Owens knew was about to be instituted, did destroy, mutilate, alter, conceal, or remove physical evidence, to wit, exhibits A6 and A7 used during June 10th, 2024 hearing, with the intent to impair its verity or availability in violation of certain statutes. That I want to learn more about. Because A6 and A7, if I believe, are the pictures of her standing in her bra and pants with the distorted like door frame and stuff, with her burrito gluten belly. So those were all Eckerd's charges. Now for the new ones. Count 8. On or about March 1st, 2024, to a material issue and believing it to be false, did make a false sworn statement, to wit, claiming that Laura Owens did not send ultrasound to Greg Gillespie, which that is again she made this statement in the deposition in the Clayton Eckerd trial, but it's in regards to Gillespie, which we have video of her saying she did not send an ultrasound to Greg Gillespie. But we also have an audio of her saying she just sent it to him and she would send it to him again, like zoomed in, screenshotted about a sonogram. So, yeah. But Gingras is like, oh, so Greg just lied about this and made it up. No, we have her on audio, but he's probably like, oh, that was before my time. But Gingras just believes what Owen says. And even no matter how many times you show that what she's saying is not true, he doesn't give a flying shit. It's ridiculous. Moves the goalpost, but he's just as insane as she is, in my opinion. Count 9. Laura Owens, on or between July 1st, 2021 and August 17th, 2022, pursuant to a scheme or artifice to defraud, knowingly did obtain a benefit from Greg Gillespie by means of fraudulent pretenses, representation, promises, or material omissions in violation of certain statutes. Now, I'm wondering with this one, are these because she benefited from something from Gillespie? Now, is what she's benefiting, is that these protective orders that she sought against Clayton and Greg? Because she did get protective orders against them. So is that the benefit that she got from these guys? Because Greg never had to pay her anything. And Clayton didn't either. So that's why I'm wondering if it is that. Is these scheme ones are about her obtaining a protective order under false pretenses, gaining a benefit to, try to advance her case with lies. So that the courts would be like, well, she had to get a restraining order against you. It was granted and all this BS, but I don't know. So I'll be interested to see about those if it has to do with the orders of protection. Count 10, on or about August 6, 2021, knowingly did take, purchase, manufacture, record, possess, or use any personal identifying information or entity identifying information of Stormy Lynn Mitchell without consent, with intent to obtain or use the identity for any unlawful purpose, to cause loss to a person, or with the intent to obtain or continue employment in violation with certain statutes. Stormy is the vanishing twin lady, and we had heard from Dave Neal that there was probably going to be justice coming and that Stormy was looking for justice herself for what Laura did to her in stealing her story and sonograms and things like this. Count 11, on or about August 6, 2021, with intent to defraud, did offer or present to Greg Gillespie, to wit, ultrasound image belonging to Stormy Mitchell, a forged instrument or one which contained false information in violation of certain statutes. So when she presented these as her own sonograms, she was, she was supplying Greg with false information because they were not hers. Count 12, on or between August 13th, 2021 and August 24th, 2021, knowingly obtained or sought to obtain property or services from Gregory Gillespie by means of a threat to accuse Gillespie of a crime or bring criminal charges against him in violation with these certain statutes. So this is the abortion coercion case she brought against him. She accused him of a crime. Count 13, on or about August 15, 2021, with intent to defraud, did offer or present to Greg Gillespie, note from Lisa Daniels, a forged instrument or one which contained false information in violation of these statutes. Count 14, on or about August 15, 2021, knowingly did take, purchase, manufacture, record, possess, or use any personal identifying information or entity identifying information of Lisa Daniels without consent, with the intent to obtain or use the identity for any unlawful purpose or to cause loss to a person, or with the intent to obtain or continue employment in violation of these. So this is another forged doctor's note, which we know she is notorious for creating these, in my opinion, fake doctor's notes. I don't think any of the doctor's notes that she has submitted have been real and based on any true and accurate information. I don't even think nurse practitioner Colleen Green, I don't think she's going off of truthful information. I think she's going off of false information. But she was willing to be there in person because Owens knew that it was not going to be, a note was not going to be sufficient because of her history. But Colleen Green is not working on factual information because it's self-reporting from Owens. None of these doctors had factual information, if they even saw her. So those are the 14 counts that she is now charged with in the Arizona Min cases of Greg Gillespie and Clayton Eckerd. Now let's break down these statutes and see what her punishments and things like that can be and what the law actually says. Okay, before we go into the statutes, let's look at some of the evidence that we have in this case regarding these charges that we know about. So here is the note from Lisa Daniels, which is a physician's assistant, basically, and this is supposedly sent August 13th, 2021 from One Medical. And we've gone over this before if you've seen any of our coverage on this case and this story. But something interesting is this is apparently a message or a doctor's note. But when you look at this screenshot of this, the box that is outlined here is get care. It's not the messages, which you would think that there would be a box around messages since that's where she is in the portal. Because we know Owens is all about her portals. But it says, thank you for coming in today. Based on your physical examination and reviewing your test results, urine, and ultrasounds, both from in our office and with outside providers, we can confirm that your pregnancy is viable and consistent with the date you provided of intercourse on June 30th or July 1st. This is not how any doctor, nurse practitioner, physician's assistant, nurse's aide, paramedic, anybody will ever write this. They do not care about the day that you had intercourse. They care about your last menstrual period. And if you had sex with somebody around a certain time frame, but they care about your last menstrual period. They do not care about your intercourse details. Okay? And I don't understand with both from in our office and with outside providers, like, what does that even mean? A fetal heartbeat was detected. Okay. Usually they might put one fetal, one fetal heartbeat and then put the BPM, beats per minute, in there. Since you took medical abortion pills, injury to the fetus is likely, but the extent of the damage is unknown at this point. Please seek care from an obstetrician going forward. Yeah, well, we know how she avoids obstetricians like the plague. I have followed up with Julie Ulrich, nurse practitioner, regarding the call she had with you and the father of your child on July 16th. She noted that he came off as a potential domestic abuser. Nobody's going to say this by listening to a person on the phone. They're just not. You know what they're going to do if they think this? They're going to make note in your chart, possibly call a wellness check and the police. But they are not going to make this assumption about a phone conversation. She noted that he came off as a potential domestic abuser and remarked on this seemingly controlling and dominating behavior. Whatever. I hope Julie Ulrich, nurse practitioner, also is a witness and is like, this bitch, I did not say this. I don't even know this guy. I don't know this woman, nothing. She said that she was concerned for your well-being and is happy to testify on your behalf. No, they do not say this. And Julie can say this herself. We don't need Lisa Daniels saying this. Please let us know if you require any additional information for your legal case. Best of luck. Well, we're going to need your medical records, ma'am, not a note from your doctor. But, I mean, we knew reading this was not accurate, but this is a forgery and assuming the identity of Lisa Daniels because Laura Owens is not Lisa Daniels. Here's some more stuff. If you can't read it, I'm going to read it to you, so do not worry. All right, so this first excerpt here says If I don't get an apology and you don't show that you meant what you said about wanting a relationship with me, I will not be having a surgical abortion and will be filing for punitive damages for $75,000. $75,000. If you don't have that, the government will garnish your wages and or put a lien on your house. Again, this has nothing to do with me wanting your money and everything to do with you being accountable for the lives you have selfishly destroyed. And like I've said in this email, if you intend to move forward with your promises to me, I will file for dismissal of the lawsuit with prejudice, meaning that I will say I was wrong about your intentions and be prevented from suing you again. I am not asking for an engagement. I am asking for you to prove that you intend to date me with intention to move down that path. The only reason I am open to this at this point is because I wanted to be proven wrong and feel like I don't make the biggest decision of my life, which will now impact so many people on the basis of a guy who made false promises to me about why it was. So that's a small excerpt. This is where she is threatening the abortion coercion 75,000. All right. And then the next one here, the email represents your last chance to avoid criminal charges. If you were to keep your many promises, then I would not report your messages as being threatening and intimidating. However, if you were sending those knowing the physical and emotional impact of your absence would have on multiple lives, you are absolutely guilty of ARS 13-1203, which can be tried as a felony. I would also file charges for criminal fraud, where the burden of proof to establish misrepresentation of fact by someone who knows the presented fact is false. In addition, the person should rely on the misrepresentation to cause injury or losses to someone else. This appears to always be punishable as a felony. Again, if I am wrong and you intend to keep your word, you wouldn't be fraudulently representing yourself. However, blocking me right after I took the pills both times means that you definitely did not have pure intentions. Finally, you wrote about not being willing to pay child support if the child were to survive, which is against the law. And I'm hoping that was just out of panic. Well, first of all, Laura, you do not get to charge anybody criminally. That is for law enforcement and prosecutors. Now, she sued him civilly for this, but he was never arrested and criminally charged with abortion coercion because, yeah, that's just not how things go. But let's look at what ARS 12 or 13 1203 is. So, if you're sending knowing the physical and emotional impact that your absence would have on multiple lives, you are absolutely guilty of ARS 13-1203. I don't know if she went through and read Title 13 and all the chapters, but 13-1203 is an assault classification. A person commits an assault by intentionally knowing or recklessly causing any physical injury to another person. Well, he didn't touch you. Intentionally placing another person in reasonable apprehension of imminent physical injury. Nope, no physical injury. Or knowingly touching another person with the intent to injure, insult, or provoke such a person. He did not touch her. He was nowhere near her. B, assault committed intentionally or knowing pursuant to subsection A, paragraph 1 is a class 1 misdemeanor. Assault committed recklessly. This is all about assault. And which is funny because, I mean, it's, assault is never funny, but she she did not read these charges very good because all those that has to do with physical assaults. That's it. Physical assaults. And saying he wants her to kill the baby is not a physical assault on her. He did nothing. Okay, so the next paragraph says, I don't want to file a police report in the first place because I don't want to have done this for nothing. I want you to be who I thought you would be. However, if you're not, this is going to be filed first thing tomorrow morning. Please do not have your civil attorney contact me regarding this criminal matter unless you plan on having her be your defense attorney. Well, you don't get to dictate what his attorney does and doesn't do. Like, his attorney is representing him, and sometimes a criminal attorney and a civil attorney can be the same person. A lot of times they're not, but they can be. Some do both. So you saying, well, you can't have this lawyer contact me. You need somebody else. I obviously contact her regarding anything related to the civil case, but I am waiting on confirmation that I should file the criminal case first. Well, you don't get to file a criminal case, lady. You can want to press charges, but you don't get to file any criminal cases. You are not a prosecutor. You have been nearly impossible to reach and do not want the police to waste their time calling your cell phone or going to your home if you won't be available. Well, you know all about wasting police resources, don't you? Finally, it's the last week I would consider having a surgical abortion, which I made an appointment for. It's not what I want to do, but I know I have done damage to the pregnancy already by taking abortion pills and would do it with your support in order to prevent him or her from coming into this world with some sort of deformity or disability. If not, I'm going to continue with the pregnancy on my own, and I would like to know which attorney should be contacted for the family law matter. Contact his attorney, he will tell you. Stop contacting Greg. I am not giving you any more chances to show that you are a good guy, and I'm not going to operate on your timetable anymore. I have plenty of evidence to include in my police report, like attachment below, unless you tell me otherwise. These 77 pages are obvious proof of an emotional abuse, manipulation, threats, and intimidation, all of which constitute domestic abuse. To me, those 77 pages probably prove that Laura Owens is the domestic abuse partner, not Greg Gillespie. Please contact me via text message tonight if you have chosen to stand by your word and want me to drop the charges. Well, he hasn't been indicted on any charges. He hasn't been arrested for any charges. There have been no charges filed on him. You have filed things in court, but there are no charges to be dropped, ma'am. If not, I will take that to mean that you are indeed accepting the charges of fraud, intimidation, threats, and domestic violence, and will take legal action accordingly. You have had weeks to show or tell me otherwise. This is the last time I will offer you any opportunity to have a say in the outcome of the pregnancy. He has never had a say in the outcome of this pregnancy because you made this up. There is a pregnancy involved, and this baby doesn't deserve to have their outcome decided on your extremely inconsistent, infrequent communication, Laura. You know what? Imaginary babies that are made up, Laura, deserve a better mother than you. You are not even a good mother to imaginary babies. And that seems almost impossible because you can make up a story and be a good mother. You can't even be a good mother in make-believe stories. You'd be a horrible children's author. Do not illustrate it either. Your words are enough. All right, this next excerpt, which is found by All the Best Research, I will have a link to their website down below. You can also follow them on Twitter as well. All right, so this last one says, I would appreciate you getting back with me as soon as you speak to Mr. Gillespie regarding the meaning behind his text yesterday. If it meant he was willing to settle, then I would drop the $120,000 in charges, the mini criminal charges, the DV charges, and the family court charge. Family court is not a charge. The DV charge, that was just like a restraining order. There are no criminal charges, I don't think, unless I don't know if there actually ever was. From what I know, there's not. Yeah, has she called the police? Yeah. But it's interesting that it went from 75,000 to 120,000. And this sounds like she's not talking to Greg here. Maybe she's talking to his attorney from this excerpt. There are no legal consequences for keeping his word, and we can move on with our lives. If he does not keep his word, we can either combine this case with the criminal case or file separately. The criminal first. You don't get to decide which is first either. I have all the information ready to give the police, and they said I could come by at any time. Yeah, they're going to tell you that no matter who you are. I would ask you to ask Mr. Gillespie to really reflect on this situation and the beautiful way he described what our lives would turn out after this. I'm attaching it. I want to just put this behind us this week, and he promises me all along. I just need a concrete answer. You just need some therapy, ma'am. Just need some therapy. Unhinged. Here is the Vanishing Twins sonograms. So the first one is when Greg Gillespie reverse Google searched the sonogram picture sent to him by Laura Owens. And then that's what the first picture is. That blog is not currently up for public viewing, which may be because of everything that's happening right now. Then in the middle one is a comparison of the blog post sonogram, which is from November 12th, 2014. That is Stormy's picture. And then down below, Laura's Fiverr sonogram. And this one shows Laura put the date. She didn't put a date on it. Okay, so the top one, Stormy, says 5 weeks and 2 days. Laura's says 5 weeks, 0 days. So she changed that a little bit. So you can see the changes that Laura made. So she was doing arts and crafts here. And so it says comparison of the 2014 sonogram from the blog post is the top, and edited sonogram Owens sent to Gillespie with the Fiverr watermark as the bottom picture. And this is from August 6, 2021. So Laura says this is her sonogram during August of 2021. Stormy's is actually from November of 2014. And Fiverr logo. Fiverr logo is right in here. It's in that. Let's erase that. This is the Fiverr logo. You can see it there. And then we have, here's the text message sent from Friday, August 6th of 2021, where Owen sends this. It says, looks like you're going to be a dad to 1 or 2 babies. Was sick enough to go to the clinic this afternoon and had to get an ultrasound to make sure I wasn't having an ectopic pregnancy. I wasn't. I found out that I've been pregnant with twins. Looks like one of them passed or isn't doing well, probably because of the medicine I took. I had the option of a surgical abortion and elected not to. If I'm going through this on my own, I will let God decide if He wants both, one or none, to be born. And the kids would deserve to know their father's side of the family. I'm giving you one more shot to blah, 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 blah. And then once again, Fiverr logo is there. You cannot miss it. I know it's like small on your screen, but it's just there and you can't miss it on any of them anymore. And it's on this one because, like I said, Greg used reverse image search, so it's going to be on this one. Obviously, it's not on the original. So I'm guessing she hired Fiverr to change it up a bit and change the formatting around it. So this is not Laura's arts and crafts. She wasn't doing arts and crafts then. She needed somebody with Fiverr to do it. But so these are the sonograms. Now let's listen to what Laura says about these sonograms. Okay, so now let's listen what Dingus Claus over here, which I wonder if he's updating his naughty list this year. But let's see what Dingus Santa and the pregnancy faker have to say, and then let's look at the evidence that contradicts her narrative that her attorney just believes without any verification. So let's listen to it and then we will talk about it.
Gillespie is who I had.
Oh, yeah. Okay. All right. Gillespie. Yeah. Oof.
I was too early on to get a sonogram or anything, so I was terminated, very, very early on.
Gillespie and Dave Neal said that you sent him a sonogram with a Fiverr logo on it or something, or a
Yeah, I don't know what they're talking about.
According to you, you never sent a sonogram to Gillespie, but he said that you did.
Right, he did, but he also knew I was too early to get a sonogram. That's why this doesn't even make any sense. I was too early, and I sued him for abortion coercion for the fact that he made me get an abortion.
So your side of the story is that you didn't send him a fake sonogram, but he has a fake sonogram. So he either sent it to himself and like made a fake email from Laura, or somebody hacked into your email. I mean, this is like back in the day, so it was way before the JSC people were even in existence.
First, it was not an email. It was a text. So y'all's hacking excuse that y'all love to use, my blog was hacked. My email was hacked. Greg is a hacker. Everybody's a hacker in David and Owens' life. It was a text, so it wasn't hacked. Nobody came in and stole her phone and did this, okay? So you don't even know if it was a text or an email. You just automatically go to hacking, which is stupid.
I'm just trying to figure out, like, what do you claim happened here with him?
But I didn't send him anything.
This is the thing where Dave Neal found some woman who said that this was her sonogram and that you stole it. That was all what that is. And you didn't steal this woman's sonogram, but she apparently is calling for you to die and be in prison because this sonogram was taken. All right.
Okay. So she says she was too early to have had a sonogram. But she never says, no, I did not send Greg a sonogram. She says, I was too early to have a sonogram. Greg knew I was too early to have a sonogram. That is not answering the question. The question was, did you send him a sonogram? She never says no. And the thing is, no, you were not too early to have a sonogram because you would have had a transvaginal sonogram if you were about 5 weeks. because about 5 to 6 weeks you can do the transvaginal. You obviously are too early to have the over the stomach one, but not a transvaginal one. Either way, now we have the audio of her contacting Greg about a sonogram. Here is the Fiverr logo as well, because she even zooms in and resends it to him. Like, she sends him the full-fledged one, which we just looked at, and then she needs to send him a zoomed-in one of this other baby that she says that her abortion coercion meds for that Gillespie forced her to take damaged this little baby thing over here. So let's listen to this audio. I've got captions on it, and then we will move into the statutes and punishment stuff with the Arizona codes, because I think it's important to understand those as well.
Aren't you excited? This is what I've always wanted, kids. Oh my gosh. My mom was a twin also, so I always knew that I had the gene.
I have the gene. Don't.
No, I do. My mom's a twin.
Okay.
Oh, she is. So in that picture, the baby looks about 5 weeks and 4 days old. And that's
5 weeks
that-
and 4 days. I estimated that. That's not what they... Greg, that's not
Wait,
at
what?
all.
No, I said
scientific.
no, the baby's about 5 weeks and 4 days. You didn't say that. It's not in the text. I'm just telling you, it looks like it's about 5 weeks and 4 days
What does
old.
that even mean?
That's exactly the day that we did it. So, like, this is
5
our...
weeks and 4 days? It says 5... I think it was 5 weeks. What are you talking about?
It says 5 weeks. Yeah, that's right when we did.
I estimated the date. What are you talking about?
Oh, you estimated the date.
Yeah.
Oh, you put it on there.
I estimated. They ask you when you think you got pregnant.
Oh.
He's trying to get her to admit that she put the date on there, which she did. She's the one who made it 5 days or 5 weeks, 0 days.
Aren't you excited?
When the
This is
original
what
one
I've always
says
wanted,
5
kids.
weeks, 2 days.
My mom
But,
was a twin also, so I always knew that I had the gene.
I have the gene. Don't.
And
No,
another
I
thing
do. My
is
mom's a twin.
in a sonogram,
Oh, she is.
they don't actually go by your last month's period in a sonogram. It
So
might
in
be
that
in there
picture,
somewhere.
the baby looks about 5 weeks and 4 days old.
But Laura,
And that's-
not
5 weeks
knowing
and 4 days.
how
I
pregnancy
estimated that. That's
babies,
not what they...
sonograms
Greg, that's
or any
not
of that,
Wait,
at
what?
all.
that
No, I
goes.
said no. The baby's about 5
Sonogram
weeks and 4
machine,
days.
Based
You
on
didn't
the
say that. It's not in the
size
text. I'm
of
just
your
telling you. It looks
fetuses,
like it's about 5 weeks and 4
What
days
does
old.
that even mean?
That's exactly the day that we
how
did it.
far along you are.
So,
So,
like, this is
while
5
like-
weeks and
your
4 days?
last
It says 5... I
period
think it was
might
5
be
weeks. What are you talking
at
about?
It says 5 weeks. Yeah,
5
that's right when we did.
weeks and 2 days.
I estimated
Maybe
the date.
the
What are you
fetus
talking about?
is
Oh,
showing
you estimated the date.
Yeah.
Oh, you put it on there.
5 weeks and 2 days. Or
I
maybe it's
estimated. They ask
showing
you when you think you got pregnant.
6 weeks.
Oh.
Which just, it doesn't mean that necessarily that your last month's period is wrong or anything
Okay.
like that. It could just mean that the baby is growing faster or slower than
Okay,
its
so
estimated size.
What were you trying to do other than be
But
sarcastic?
it's the sonogram machine
Nothing. I'm just excited. We're gonna have a
that
kid.
does all that calculation. It is not the woman. Because
What?
a lot of times, if you've noticed, you can be like, oh, because we have on a calendar, you're like, okay, every Saturday, I'm a new.
What are you
week
What are you
pregnant.
trying to
So
do?
every
What are you trying to say?
Saturday,
What do you mean?
I'm.
Because you're obviously
You know,
not
I was
excited.
5
So
weeks
what?
pregnant, and
Didn't
then
your- so your pills
Saturday
didn't work?
comes around, I'm gonna be 6
I
weeks
didn't say my
pregnant.
pills didn't work. I
When
got
you
an
go
ultrasound
into your
today.
sonogram,
I know, but they didn't
sometimes
work.
you'll notice that the
That the-
sonogram doesn't
Did you not
actually
see that the
line
other thing
up
is like the
with
tiniest thing you've ever
calendar
seen? It
days
clearly stopped
that
the
you
growth in
have.
that.
Wait, what thing?
But a person that's
That's
never
not a
been
child.
pregnant
There's
is
no
not going
twins
to
in
know
this
that.
picture.
So
Yeah, there are.
this
Do you
proves
Do you want me to zoom in on it for
she's
you?
a liar over and over again.
Yeah, I don't know. There's no twins in this photo.
Yeah, there is.
Where? I don't. No, I know how to read ultrasounds. This is a single baby.
You know how to read ultrasounds?
Yeah.
If you go down here, I'll just screenshot it for you.
So what? You want me to? Do you think that you want me to tell you I made a mistake, and you want me to? What did you say?
Well, you clearly were never planning to see me again.
Wait, you want me to stop and tell you? Let's go see the lawyer together.
Let's go what?
Let's go to the lawyer together. We'll talk to the lawyer.
That's what you would like to do?
Yeah.
You don't want to do... So you were just totally bullshitting
Wait,
me
so
then?
you want to have a surgical... Oh, wait, you want to have a... Wait, I'm just reading still. You want to have an abortion, a surgical abortion.
That's what I thought you wanted.
So you want to go have a surgical abortion?
That was what I thought you wanted.
So this is where she screenshots and sends him this picture that I have on the screen as well. This is the screenshot she sent him during this phone call. In a text message, not an email that has been hacked. But she is so mad. Like, what do you mean you're excited we're going to have a baby? You didn't want this baby. What do you mean you're excited? Like, you're being sarcastic. Like, she's so mad that he is acting like he is happy about this situation. Like, it is infuriating her, and she does not know what the hell to think, which I love so much. But she's like, you know how to read sonograms? Like, that worries her because she clearly doesn't. So she's like, oh shit. Like, he knows how to read these, which is not good because, like she says, to her, all sonograms look the same.
Greg, I'm serious that I would do a paternity test at 8 weeks. I'm not kidding you.
That's cool.
I don't deserve this. I deserve you to keep your...
So wait, why didn't you answer the question about the photo online?
I did. What did you want me to say?
Why is it your photo?
It's not my photo.
Why not? You don't wait. Didn't you find it peculiar how similar it looks?
No, I don't find anything peculiar with an ultrasound photo. They all look the same.
They do?
All ultrasounds look virtually the same. I don't find anything weird with that.
You have experience in this?
With ultrasound?
Yeah.
I've had pregnant friends before.
Do you have any currently?
Yeah, why?
Who?
Well, it's my sister's friend who's supposed to be in her wedding, but she's due any day now.
Oh, that's cool.
Why?
Well, does she live in Phoenix?
No, she lives in San Francisco. Why?
Oh. So you got pregnancy friends.
It's not even a friend. It's my sister.
Okay.
Okay. So she's very confused by what Greg is doing right now. And she, of course, is flipping out and everything like that. But I thought you said you didn't send him a sonogram. I thought you said you were too early for a sonogram. So, Laura, like, you're screwed. Gingras, love to know your thoughts on this. Like, do you take back your dingus Santa statements about this? Or do you still believe Laura? Okay. Arizona Revised Statutes, Title 13. This is why I was talking about she likes 13 dash things. But since Laura admires Title 13 and the Criminal Code of Title 13 and all its chapters, and she seems to have read up on them, even though she doesn't actually understand them, as we've proved earlier, here is the ones she has been that are new. So 132701, this is in regards to count 8 definition. Material means that which could have affected the course of the outcome of any proceeding or transaction. Whether a statement is material in any given factual situation is a question of law. I will be going over material and immaterial type statements in a upcoming video on some of Gingris's bloggings to go more in detail about this. 2, a statement means any representation of fact and includes a representation of opinion, belief, or other state of mind where the representation clearly relates to state of mind apart from or in addition to facts which are the subject of the representation. 3, sworn statement means any statement knowingly given under oath or affirmation attests to the truth of what is stated, including a notarized statement, whether or not given in connection with an official proceeding. So, was it material to the case? Yeah, whether you're pregnant or not pregnant, whether there was real babies to abort or not abort, that's a material fact. Did you give a statement? Yep. That you represented as fact. But it can include a representation of an opinion or a belief or other state of mind. And then, was it a sworn statement? Was it under oath? Was it in a filing? Was it in a deposition? All those are sworn statements. I believe what you say to the police is also considered a sworn statement, or you can have something notarized and it can become a sworn statement. Yes, we know she made material sworn statements that are provably false. So I don't think they'll have a problem proving this. Count 8. Count 8 as well is the perjury classification of these sworn false statements of material facts, as a person commits perjury by making either a false sworn statement in regard to a material issue, believing it to be false. A false unsworn declaration, certificate, verification, or statement in regard to a material issue that the person subscribes as true under penalty of perjury, believing it to be false. B, perjury is a class 4 felony. So this is why I say perjury is sometimes a little bit difficult, because you can't just say, well, they lied on the stand, they lied in their thing, but did they lie about something that is immaterial? Or was it material in the case, whether, like, if this piece of information, does it being changed change the entire case? Or is it something immaterial, not relevant, and would be like harmless? Like if you're like, oh, the car was gray, not green. It's not a material fact. Because it's like, well, we have you on surveillance driving this, and maybe the person was colorblind. Like if Bruce was trying to say, it was a blue car, but it was in fact a brown car. That would not be him committing perjury, So, sorry, Bruce, I used you for an example, but I'm going to pick on you in that regard today. Also, 13-2706 of the Criminal Code, limitation on defenses. This is still in regards to count 8. It says, it is no defense to prosecution under the chapter that 1, the statement was inadmissible under the rules of evidence, So whether she made a statement that came in at trial or didn't come in at trial, if you lied about a material fact, it is still considered perjury. You can't say, well, that wasn't used at trial, which she could try to say when it comes to certain things, like, it wasn't submitted into evidence, like she says, these sonograms. I didn't submit them. No, but you did them and you lied about them. You admit they are your sonograms, whether we admitted them or not, whether I admit them or you admit them or whatever, whether it comes in at trial has nothing to do with it. Because there's a lot of things and evidence and discovery that happens that for some reason, whether it's hearsay or some other exception in the rules of evidence, that it can't be brought in, but it doesn't mean that you still can't lie about evidence that doesn't get admitted. Because you can lie about things that end up being inadmissible because they can't be verified, because maybe you deleted metadata or something. 2, the oath or affirmation was taken or administered in a regular or in an irregular manner. Or 3, the defendant mistakenly believed the false statement to be immaterial. So when we heard her on the stand talk about how it was just a minor thing. It was just a little minor perjury, as the song says with Megan Fox. It doesn't matter if she thinks it's minor or not. That is not a defense. There is no defense on those 3 things. B, the provisions of law which declare that evidence obtained upon examination of a person as a witness cannot be received against him in a criminal proceeding do not forbid giving such evidence against the person upon any proceeding founded upon a charge of perjury committed in such examination. All right. Now moving to count 9. Arizona Revised Statutes, Title 13, Criminal Code 132310, Fraudulent Schemes and Artifices, Classification, Definition. A person who, pursuant to a scheme or artifice to defraud knowingly, obtains any benefit by means of false or fraudulent pretenses, representations, promises, or material omissions is guilt of a Class 2 felony. So if she benefits from anything under these false and fraudulent pretenses or false or fraudulent representations that she makes, or false promises, fraudulent promises, or false or fraudulent materials, or she omits information like, oh, I omitted that I went to Los Angeles Planned Parenthood, which she omitted that she didn't actually go there either. They is guilty of a Class 2 felony. B, reliance on the part of any person shall not be necessary element of the offense described in subsection A of this section. C, a person who is convicted of a violation of this section that involved a benefit with a high value of $100,000 or more, or the manufacture, sell, or marketing of opioids is not eligible for suspension sentence, probation, pardon, or release from confinement on any basis except pursuant to codes. Until the sentence imposed by the court has been served, a person is eligible for release pursuant to statute, or the sentence is commuted. D, the state shall apply the aggregation prescribed by 13-1801 subsection B to violations of this section in determining the applicability punishment. E, for the purposes of this section, scheme or artifice to defraud includes a scheme or artifice to deprive a person of the intangible right of honest services. Yeah. They weren't well, I mean, technically they were receiving a service from Owens. But they're not receiving honest anything from Owens. But it's mainly like A and B. that we're dealing with this on these, but they didn't put the subsections when they did the indictment, so we're just going over them generally. So like I said, that was 19, or count 9 for Greg Gillespie. Arizona Revised Statutes Title 13, Criminal Code 13, 2008, taking identity of another person or entity classification. This is for counts 10 and 14. A person commits taking the identity of another person or entity if the person knowingly takes, purchases, manufactures, records, possesses, or uses any personal identifying information or entity identifying information of another person or entity, including a real or fictitious person or entity without the consent of the other person or entity, with the intent to obtain or use the person's or entity's identity for any unlawful purpose or to cause loss to a person or entity, whether or not the person or entity actually suffers any economical loss as a result of the offense, or with the intent to obtain or continue employment. So, whether the person that you make up is real or not. So, Chase J. Jones or this Lisa Daniels person or Stormy Mitchell. Let's say maybe a tag, but definitely a Chase J. Jones. You assumed all these people's identity. So whether the person is real or fictitious, if you did it with the intent to do any unlawful thing that causes loss, that doesn't even have to be economical, you will be breaking the law. B, on request of a person or entity, a peace officer in any jurisdiction in which an element of an offense under this section is committed, a result of an offense under this section occurs, or the person or entity whose identity is taken or accepted resides or is located shall take a report. The peace officer may provide a copy of the report to any other law enforcement agency that is located in the jurisdiction in which a violation of this section occurred. So we're looking at Section A mainly for this purpose. So continuing on with that, for counts 10 and 14, C, if a defendant is alleged to have committed multiple violations of this section within the same county, which she has made up many in Maricopa County, many identities have been made up or stolen. The prosecutor may file a complaint charging all of the violations and any related charges under other sections that have not previously been filed in any precinct in which a violation is alleged to have occurred. If defendant is alleged to have committed multiple violations of this section within the state, the prosecutor may file a complaint charging all the violations and any related charges under other sections that have not been previously filed in any county in which a violation is alleged to have occurred. She has 2 of these violations. D, the section does not apply to a violation of 4241 by a person who is under the age of 21 years of age. E, taking the identity of another person or entity is a Class 4 felony. Moving to count 11 and 13, Arizona Revised Statutes, Title 13, Criminal Code 13, 2001, definition. 1, access device means any card, token, code, account number, electronic serial number, mobile or personal identification number, password, encryption key, biometric identifier, or other means of account access, including a canceled, revoked access device that can be used alone or in conjunction with another access device to obtain money, goods, services, computer or network access, or any other thing of value that can be used to initiate a transfer of anything of value to a coin machine, which she didn't use here. 3, complete written instrument, which I believe is what we're dealing with here, possibly, means a written instrument that purports to be genuine and fully drawn with respect to every essential feature. So a complete written instrument is a document that appears to be fully and genuinely executed in every essential detail with no missing information or required additions, it is considered to a complete document in all respects, such as a fully signed contract or a completed check, as opposed to an incomplete written instrument, which would need more information. So fully drawn is, is complete with all the essential aspects. Purports to be genuine means like it looks authentic. No missing parts. It does not require any additional context or authenticity to be considered final. Incomplete, it's missing essential parts, like maybe a signature. False completion is an incomplete instrument, can be falsely completed by adding or changing information without authorization to make it appear genuine, which Laura has done for sure. So this talks about documents and stuff. All right. Still with counts 11 and 13, 4 entity identifying information includes, if the entity is a person other than a human being, any written document or electronic data that does not purport to provide information concerning the entity's name, address, telephone number, employer identification number, or an EIN, account number or electronic serial number, the identifying number of the entity's depository account, or any other information or data that is unique to, assigned to, or belongs to the entity that is intended to be used to access service funds or benefits of any kind that the entity owns or to which entity is entitled. 5, falsely alters a written instrument, means to change a complete or incomplete written instrument without the permission of anyone entitled to grant it by the means of counterfeiting, washing, erasure, obliteration, deletion, insertion of new matter, connection together different parts of a whole or more than one genuine instrument, or transposition of a matter or any other matter so that the altered instrument falsely appears or purports to be in all respects an authentic creation of its ostensible marker or authorized by him. So let's go to 6. Falsely completes a written instrument means to transform an incomplete written instrument into a complete one by adding, inserting, or changing matter without the permission of anyone entitled to grant it, so that the complete written instrument falsely appears to purports to be in all respects an authentic creation of its ostensible maker or authorized by him. So far we have 3, 5, and 6 that seem to be pertained. Let's see what else under this statute she might also fall under. 7, falsely makes a written instrument. Well, we know she likes to make false things. I think the Lisa Daniels things is probably around 7. Means to make or draw a complete or incomplete written instrument that purports to be authentic creation of its ostensible maker, but that it is not either because the ostensible maker is fictitious, or because, if real, the ostensible maker did not authorize the making or drawing of the written instrument. 8, forged instrument means a written instrument that has been falsely made, completed, or altered. Sonograms and doctor's notes. 9, incomplete written instrument means a written instrument that contains some matter by the way of content or authentication, but that requires additional matter to render it complete written instrument. Like incomplete would be like it doesn't have a signature. Personal identifying information. And it goes through all of those. You can pause it if you want to read it, but we know what personal identifying information is. All right, still with count 11 and 13. 11, slug means an object or article or device that by virtue of its size, its shape, or any other quality is capable of being inserted, deposited, or otherwise used in a coin machine. So we don't have that here. 12, written instrument means either any paper document or other instrument that contains written or printed matter or its equivalent. And then B, tokens and trademarks and badges and seals and symbols and privilege or identification, access device, things like that. So it looks like 3, 5, 6, and 7 along with some others, are definitely some subsections that Owens is going to be guilty of under this statute. So lots of reasons to be guilty in this one. All right, the forgery classification for counts 11 and 13. A person commits forgery if with intent to defraud the person. Yep, she intended to defraud all these men. 1, falsely makes, completes, or alters a written instrument. Or 2, knowingly possesses a forged instrument. You know if they're forged if you forged them. 3, offers or presents, whether accepted or not, a forged instrument or one that contains false information. B, the possession of 5 or more forged instruments may give rise to an inference that the instruments are possessed with an intent to defraud. If we counted up all her sonograms and doctor's notes, we definitely have more than 5 forged instruments. C, forgery is a class 4 felony, except that if the forged instrument is used in connection with the purchase of renting, delete. Okay, so that has nothing to do with a house. For the purposes of this, okay, so it's a class 4 felony unless it has to deal with house things, and then it's a class 3 felony. Count 12, Arizona Revised Statutes, Title 13, Criminal Code 13-1801, definitions. A, in this chapter, unless the context otherwise requires, 1, check means any check, draft, or other negotiable or non-negotiable instrument of any kind. 2, control or exercise control means to act so as to exclude others from using the property except on the defendant's own terms. 3, credit means an expressed agreement with a drawee of a payment of check. Okay, these don't. 4, deprive means to withhold the property interest of another permanently for such a long time period and the substantial proportion of its economic value, usefulness. Okay. Intent to restore the payment. Stored only on payment or of any reward or other compensation to transfer or dispose of it so that it's unlikely to be recovered. 5, draw means making, drawing, uttering, preparing, writing, or delivering a check. 6, funds means money or credit. Okay, so these are definitions for count 12, and then it continues on. So I don't think any of these have to do with it. Let's see what else. 7, issue means to deliver or cause to be delivered a check to a person who thereby acquires the right against a drawer, person. Okay. 8, material misrepresentation means a pretense, promise, representation, or statement of present, past, or future fact that is fraudulent and that when used or communicated is instrumental in causing the wrongful control or transfer of property or services. The pretense may be verbal or it may be a physical act. Means a transport, obtain. You have to obtain it. Pass means for a pay or holder. Been drawn. Okay, these have to do with a check, so I'm not understanding this one. If somebody can clue me in, great. Still count 12. Property. We know property is property of another. So property means anything of value, tangible or intangible, including trade secrets. Okay, so trade secrets can be considered property. Oops, sorry. Property of another means property in which any person other than the defendant has an interest on, which the defendant is not privileged to infringe, including property in which the defendant also has an interest, notwithstanding the fact that the other person might be precluded from civil recovery because the property was used in an unlawful transaction or was subject to forfeiture as contraband. Property in possession of the defendant is not deemed property of another person who has only a security interest in the property, even if legal title is the creditor pursuant to the security agreement. 14, services include labor, professional services, transportation, cable, video, computer, communications, gas, electric, hotels, restaurants, leased, elsewhere, admissions to exhibitations and use of vehicle. Okay, I'm still not understanding this particular charge. I get it has to do with like forgery and money and accusing somebody of a crime. Maybe we're getting there, but I don't know. Let's see. Still not there yet, in my opinion. If we passed it, somebody let me know. 15, value means the fair market value of a property or services. Property is undermined, value of trier fact shall determine. B, in determining the classification of the offense, the state may aggregate in the indictment or information amounts taken in thefts committed pursuant to one scheme or course of conduct, whether the amounts were taken from one or several persons. Okay. I'm not understanding this because I don't think she got any money off of Greg. Maybe she did, but I don't think she did. So, if you have more information on that, put that in the comments, please. Okay, count 12. Arizona Revised Statute, Title 13, Criminal Code 13804, theft by extortion. Classification. 1, cause physical injury to anyone by means of a deadly weapon or dangerous instrument or cause death or serious physical injury to anyone. 2, cause physical injury to anyone except as provided in paragraph 1. 3, cause damage to property. 4, engage in other conduct constituting an offense. 5, accuse anyone of a crime or bring criminal charges against anyone. 6, expose a secret or an asserted fact in a social media messages as defined as 16901, or in any other manner, whether true or false, tending to subject anyone to hatred, contempt, or ridicule, or to impair the person's credit or business unless the threat is based on a plausible claim of right to the property or services obtained or sought to be obtained. 7, take or withhold action as a public servant, or to cause public servant to take or withhold action. 8, cause anyone to part with any property. Okay, so they're concentrating on 5 here, accusing somebody of a crime or bringing criminal charges against someone. I think these have to do with the OOPs. Still count 12, take or withhold action regarding an alleged claim of easement or other right of access to an adjoining property. Properties A and B. B, it is a defense to a prosecution under subsection A, paragraphs 5, 6, and 7 of this section if a reasonable person would believe that the property or services were obtained or sought to be obtained by the threat of reasonable accusation, exposure, lawsuit, or other invocation of official action. 6, theft by extortion is a class 4 felony, except that theft by extortion under subsection A, paragraph 1 of this section is a class 2 felony. Okay. All right. So those are all the statutes that she violated. So now we're going to kind of look at the statutes that they listed for like punishment, basically. So all these next ones that we're going to be covering cover counts 8 through 14. They might even cover all 14, 1 through 14. But for sure, for this video, it covers all of Gillespie's charges that they listed these on. So, Criminal Code 13701, sentence of imprisonment for felony. Pre-sentence report, aggravating and mitigating factors, consecutive terms of imprisonment, and definition. A sentence of imprisonment for a felony shall be a definite term of years, and person's sentence, unless otherwise provided by law, shall be committed to the custody of the State Department of Corrections. B, no prisoner may be transferred to custody of the State Department of Corrections without a certified copy of the judgment and sentence signed by the sentencing judge and a copy of recent pre-sentencing investigation report unless the court has waived preparation of the report. So when Laura is sentenced, if she goes to trial, they will not sentence her on the same day. Sentencing will be a different day so that they can do a pre-sentencing report, give times for victims to come and gather their thoughts and everything like that, to give victim impact statements and so forth. So anybody that's expecting her to be sentenced that day is going to be sadly mistaken. That will be at a later date, usually 30 to 90 days. It also sometimes depends on how they're backed up. Does Laura cooperate in the pre-sentencing investigation? And this is to come up with aggravating and mitigating factors, and to figure out where on the scale of sentencing should she fall. Should she get the least amount for that thing that she's found guilty of, or should she receive the max? A mitigating factor for her will be that these are the first 14 things that she's ever been charged with criminally. But this is why Rachel Mitchell put in there that I don't want her considered a first-time offender on basically counts now 2 through 14. She can be considered a first-time offender on count 1, but 2 through 14, I want her to be considered a repeat offender. Or maybe the first count of perjury, she can be considered a first-time offender, but the other 4 counts of perjury, she should not be considered a first-time offender when it goes to sentencing. And she will have to be sentenced on each of the 14 accounts. So it'll be, okay, count 1, you're going to get, 1 year in prison. Count 2, you're going to pay a fine. Count 3, you're going to have probation consecutive to count 1 and 2. Things like that. But she will be charged separately for each individual count. She will have a sentence for all of them. And then you add all the sentencing up, and that's when you get basically the big number and the big amount that she will be serving or paying. C, the minimum or maximum terms imposed pursuant to those may be imposed only if one or more of the circumstances alleged to be an aggravation of the crime are found to be true by either of the trier of fact, which would be a judge or a jury, beyond a reasonable doubt, because that is a standard in a criminal case, not more likely, not more probable, beyond a reasonable doubt. Like you cannot think of any other reason on this planet other than aliens coming down and doing this and possessing Laura, and it was actually an alien who did this, because that's not a reasonable doubt. It's not beyond all doubt. A reasonable person. Admitted by the defendant, so Laura could say, yes, I did these things, except that an alleged aggravating circumstance under subsection D, paragraph 11 of this section shall be found to be true and by the court, or in mitigation of a crime are found to be true by the court, or on any evidence or information introduced or submitted to the court or the trier of fact before sentencing, or any evidence presented at trial. And factual findings and reasons in support of such findings are set forth on the record at the time of sentencing. D, for the purpose of determining the sentence pursuant to subsection C of this section, the trier of fact shall determine and court shall consider the following aggravating circumstances, except that the court shall determine aggravating circumstances under this paragraph 11 of this subsection 1, infliction or threat infliction of serious physical harm, except in this circumstance, is an essential element of the offenses of conviction that has been utilized to enhance the range of punishment. Number 2, use, threatened, or possession of a deadly weapon, or dangerous instrument. So don't really have that. 3, if the offense involves taking of or damage to property. 4, presence of an accomplice, which might have that. 5, heinous, cruel, or depraved manner in which the offense was committed. 6, committed the offense as consideration for the receipt or in expectation of a receipt or of any pecuniary value. The defendant procured the commission of the offenses by payment, promise of payment, or anything of pecuniary value. At the time of the commission of the offense, the defendant was a public servant. Nope. Number 9, the victim, or if the victim has died as a result of the conduct of the defendant, the victim's immediate family suffered physical, emotional, or financial harm. So all our victims right now that we know about are living. So it will be the victim suffered physical, emotional, or financial harm. Oh, has died as a result of the conduct. So we don't have that. Never mind. We don't have number 9. 10, during the course of the commission of the offense, a death of an unborn child at any stage of its development occurred. What if the development started in her head and not like a gestational unborn baby? Like it was an in your brain baby, not an in your stomach baby. What are there any laws about that stuff? Like, got any punishments for that? 11, the defendant was previously convicted for a felony within the 10 years immediately preceding the date of the offense. A conviction outside the jurisdiction of the state for an offense that is committed in the state would be punishable as a felony if is a felony conviction for the purposes of this paragraph. So this is part of the whole first time felon, first time, criminally being charged with anything, is because a lot of these things happen on different dates. Has she technically, once she is found guilty, which means she has been convicted, because all of them are different dates, is this going to be an aggravating factor because she has then been convicted, but it says previously convicted of things. So that'll be an interesting thing to look at. 12, the defendant was wearing body armor. I mean, is a pregnancy body armor? 13, the victim of the offense is at least 65 years of age. Nope. Or is a person with a disability as defined in 38,492 subsection B. Let's see. Does she have any of those disabilities, or will she have them by the time this happens? 38,492 B. Let's see here. That's veteran. Let's see. Physical or mental empowerment. Action. Well, it doesn't like list what the things are. But maybe that's going to be a mitigating factor for her, is that she apparently has disabilities. I don't know that they will classify as that because you can be autistic and go to jail. You can have GI bleeds and go to jail. You can even have cancer, go to jail. You can be pregnant, go to jail. So I don't think that one's going to work in her favor as much as she wants it to. 14, the defendant was appointed pursuant to Title 14 as a fiduciary, and the offense involved conduct directly related to the defendant's duties to the victim as fiduciary. Not applicable here. Evidence the defendant committed the crime out of malice towards the victim because the victim's identity in a group, or because the defendant's perception of the victim's identity. Okay, no. She did do it with malice, I'll say that. 16, the defendant was convicted of a violation. Alcohol, driving motor vehicle. Nope, sorry, that's her attorney, not her. 17, lying in wait to ambush them. I mean, she did kind of stalk Greg and these other guys, but whatever. The offense was committed in the presence of a child, and any of the circumstance exists or set forth. Once again, our make-believe babies, are they in the presence of a child? See, they don't even have laws for make-believe land. We're going to have to make them up. And what I say is straight to jail. Like, do not pass go, do not collect $200. And we don't have trials. We just determine on vibes, okay? In imaginary land. 19, the offense was committed in retaliation for a victim either reporting a criminal activity or being involved in an organization other than law enforcement agency that established for the purpose of reporting or preventing criminal activity. She did get these OOPs in retaliation of things. Oh, I gotta get to it first. I gotta avoid service so that I can get to them and do these things first. So maybe. She did not impersonate a peace officer. She didn't, as far as I know, she didn't use a stun gun or electrical jolts. So no gun things. I don't think trackers were used. Maybe the next victim she would, but I don't think so. Training program, remote stun gun, none of these apply to her. Sorry if none of these apply. I am just put the complete statute. So if you want to pause and read these statutes, you can, or you can go find them yourself. During or immediately following the commission of the offense, the defendant committed a violation of certain other things. Those aren't listed. Defendant was convicted of a violation of, defendant recruited, enticed, or obtained the victim from a shelter. No, she did not do that. The defendant was convicted of a violation that the defendant committed a crime out of malice towards the victim because, nope, has nothing to do with police officer. I don't think she would ever be with a police officer because that would not be good for her. Police officers are not her type. Like, she just wants them to do work for her. Don't work against her, work for her. And she's not going to date you because then she can't commit her crimes. She did not wear a mask. She wore a fake belly, but she didn't wear a mask. I mean, she wanted to mask like she was a girl next door. And then you find out she's not. She's the daughter of Satan. Any other factor the state alleges is relevant to the defendant's character or background or the nature or circumstances of the crime. All right. E, for the purpose of determining the sentence pursuant to subsection C of this section, the court shall consider the following mitigating circumstances. So those other things were aggravating. These are mitigating. The age of the defendant, the defendant's capacity to appreciate the wrongfulness of the defendant's conduct or to conform the defendant's conduct to the requirements of law was significantly impaired, but not so impaired as to constitute a defense to prosecution. She's not going to be able to say she was insane because she knew right from wrong. Do I think she would probably try to be found incompetent? Like, I don't understand these charges. Like, I just can't help in my defense because I don't know what is happening here. I don't think she'll be found competent too. She may try to act like she's not, but she's going to be found competent if she tries that bullshit. The defendant was under unusual or substantial duress, although not to a degree that would constitute defense to prosecution. No, any duress she brings on is her own. The degree of the defendant's participation in the crime was minor, although not so minor as to constitute defense to a prosecution. No, she's major. During or immediately following the commission of the offense, the defendant complied with all duties imposed. She didn't comply with no duties. She even lied to commissioner duty, okay? She didn't do nothing right. 6, any other factor that is relevant to the defendant's character or background or to the nature or circumstance of the crime that the court finds to be mitigating. She's like, well, I like horses and I am good to animals. I love animals. Yeah, that's not going to save you here. That you are nice to animals. Like, should you even be using Sirico 91? Or is he just too old and should not be doing this if he can barely jump broomsticks? What are you doing? Is Sarah Q being abused? I'm just kidding. I am just kidding. I am not actually accusing her of animal abuse. I do believe she loves animals. Because, like, oh my God, if she didn't have animals and she really had nothing or nobody to love her, I really don't know how much worse she would be if she didn't even have an emotional love of an animal. Again, these are all to go with counts 8 through 14. These are the things that the indictments, stated. F, if the trier of fact finds at least one aggravating circumstance, the trial court may find, by a preponderance of the evidence, additional aggravating circumstances. In determining what sentence to impose, the court shall take into consideration the amount of aggravating circumstances and whether the amount of mitigating circumstances is sufficiently substantial to justify a lesser term. So if you have 5 aggravating and 1 mitigating, yeah, you're not going to get a lesser term. Now, if you only have 1 aggravating and 6 mitigating, yeah, you would probably get a lesser term. But no, not here. I think she'll get mid to least. I don't think she's getting the max on any of them. I would be shocked if she did. We could all hope things like that, but I don't see that as a reality. G, the court, in imposing a sentence, shall consider the evidence and opinions presented by the victim or victim's immediate family and any aggravating or mitigating proceeding, which is like the victim impact statements, or in the pre-sentencing report, which is they're like, hey, we've talked to her, we've done a mental evaluation of her, all these things, and here you go, judge. The intentional failure by the court to impose the mandatory sentences or probation conditions provided in the title is malfeasance. For the purpose of this section, trier of fact means jury unless the defendant and state waive a jury, in which the case the trier of fact means the court. I don't think she's going to do a bench trial. I think she's going to have to do a jury and hope to God that one person buys into her bullshit on all 14 and just believes like Gingras this woman. I don't see that happening, but that's what would have to happen. She's going to have to convince 6 to 12. I don't know what it's going to be for this type of case. Jurors to buy her bullshit. And she hasn't even been able to do that to 6 people online. 6 people online don't even buy her story, which is almost unheard of in criminal cases. Criminal Code 13702, first-time felony offenders sentencing definition. A, unless a specific sentence is otherwise provided, the term of imprisonment for a first felony offense shall be the presumption sentence determined Pursuant to subsection D of this section, except for these felonies involving a dangerous offense or specific sentence and is otherwise provided, the court may increase or reduce the presumptive sentence within the ranges set by subsection D of this section. Any reduction or increase shall be based on the aggravating and mitigating circumstances and shall be within the range prescribed in subsection D of this section. And so what we'll see here in a little bit, I'll show you, is you're given a range for first-time felony offenders, and then you'll also be able to look at the somebody that's not a first-time offender, and their sentencing guidelines. There are always sentencing guidelines, and you don't have to, but most judges do. To me, an ethical and good judge does stay within those parameters. And as you should, unless something is just really egregious and you've never done anything wrong in your life and then you just become a murderer one day, like Lori Vallow. But they will give you a minimum and a maximum. And a minimum and maximum, let's say the minimum is 1 year, the maximum for that particular count and charge is 5 years. The judge can go anywhere in 1 to 5, and on sentencing, the judge is not going to be overturned if he stays in those guidelines. Now, if he decided to give her 10 years on something where the guidelines say you should have given her 5, then on appeal, they can reverse that and say, no, there was no reason to give 10. You were being unfair, biased, or whatever. But if they stay in the sentencing guidelines, there's not going to really be any room for appeal on the sentence itself. They're not going to really be able to argue that the sentence isn't fair as long as the judge stays in these sentencing guidelines. I hope that makes sense. If a person is convicted of a felony without previously being convicted of any felony, and if at least 2 of the aggravating factors apply, the court may increase the maximum term of imprisonment otherwise authorized for that offense to an aggravated term. If a person is convicted of a felony without having previously been convicted of any felony, and if the court finds at least 2 mitigating factors that apply, the court may decrease the amount of term of imprisonment otherwise authorized for the offense. So if they find 2 aggravating things, that 5 years he may say 6 because of these aggravating factors. Or if there's 2 mitigating factors, the court may say, all right, 1 year is the least that I'm supposed to give you, but I'm actually just going to give you 6 months because of these mitigating factors. There has to be an explanation from the judge, but usually judges really do try to stay within that guidelines. And I don't think that this judge or the prosecution is going to try to have the court or anybody go outside of those guidelines, knowing how Owens and especially her mother and stuff like that are. Because they know that there's going to be appeals and she's going to throw fits and everything else, and they do not want any of the stuff getting overturned on appeal because of trying to just get something that they shouldn't be. We may want life. Some people might want life for her, but that is not reality. And there are guidelines and things that we need to follow, and we need to follow them for the worst of people and for the best of people. We can't just pick and choose who we follow them for and don't follow them for. The aggravating or mitigating terms imposed pursuant to subsection D of this section may be imposed only if at least 2 of the aggravating circumstances are found beyond a reasonable doubt to be true of the trier of fact or admitted to by the defendant, except that an aggravating circumstance under paragraph 11 shall be found to be true and correct by the court, or in mitigation of the crime are found to be true by the court on any evidence or information introduced or submitted to the court or the trier of fact before sentencing, or any evidence presented at trial, and factual findings and reasons in support of these findings are set forth on the record at the time of sentencing. D. The term of imprisonment for a presumptive minimum, maximum, mitigating, or aggravated sentence shall be within a range prescribed under this subsection. The terms are as follows. So here's like the chart I was talking to you about. So the minimum and maximum, and then presumptive. A lot of times you can just go in the middle. So let's look at class 4 because that's a lot of what she has. She does have others, but let's look at the class 4. So the minimum of a class 4 is 1.5 years. So, and that would just be on one of her charges. So if she gets guilty on all her class 4s, that's going to be minimum of 1.5 plus 1.5 plus 1.5, so on. But the maximum they could do is 3 years. But you could go in the presumptive and you can go in the half and just do 2 years or 2.5 years, okay? And then they even list the mitigated time that's okay and the aggravated time is okay. And they said, remember, they said if you find 2 mitigating factors, you could do the mitigated of 1 year instead of 1.5. So they even have guidelines for the mitigating and aggravating things too here. And then if there's 2 aggravating factors that they find along with this, they could go up to even 3.75. But my guess is on her class 4s, it'll be 1 to 2.5 years is my guess. On all her class 4s. This is if she doesn't take a plea deal, and this is why she needs to take a plea deal, because she gonna rack those numbers up. Like you go to the dollar store, that 25 cents, or that 50 cents extra that it cost after Dollar Tree went from $1, everything $1 to $1.25 or to more, those quarters add up. And you can end up spending a lot of time or money. So she really needs to think about this. I'm pretty sure her lawyer is going to explain all this to her. Now, whether she takes it all in or she's like, Gingras, help. This is what the other attorney is saying. She shouldn't listen to Gingras. But she needs to be listening to her lawyer and understanding the seriousness of this instead of trying to cause chaos all over the place. This is not a game, Laura. You've been playing a game for way too long, and now the game is done. Through you guys. E. The court shall inform all the parties before sentencing occurs of its intent to increase or decrease a sentence to the aggravated or mitigated sentences pursuant to this section. If the court fails to inform the parties, a party waives its right to be informed unless the party timely objects at the time of sentencing. If you do not object when all this is happening, you waive your right. Just like if you do not object to something in the moment in a trial, you waive your right. And you cannot appeal it. You waive your right to it if you don't say crap. F, for the purposes of this section, trier of fact means jury unless the defendant, okay, or it could be the court, all right. And so that was prison stuff. Now we are talking about fines for felonies, which is Criminal Code 13801. A sentence to pay a fine for a felony shall be a sentence to pay an amount fixed by the court not more than $150,000. B, a judgment that the defendant shall pay a fine with or without the alternative of imprisonment shall constitute a lien in like manner as a judgment for money and rendered in a civil action. C, this section does not apply to an enterprise. Well, we don't even need to worry about this because Owens is not an enterprise as much as maybe her family thinks that they are. So I think it should be a condition that Owens cannot write a book about this. Or she can write a book about it. She can. She can't profit off of any of it. That any money that she receives by TV or movies or court appearances, like not court appearances, but interviews, any money she receives from that or any money that she tries to make by selling a book, she does not get to collect on, because you do not get to collect on crimes against victims. That goes to paying court costs and restitution to Greg and Clayton, because she's got lots of money to be paid all over the place. So go ahead and write your book. It's just going to pay off your fines that you owe these men, or at least owe Clayton, but you'll owe Greg as well. You like writing so much. Write you a book and it will help pay your fines. Okay? You're going to have a lot of free time in jail or prison. It's not going to be jail. Jail is not going to be a thing. You're going to do prison, baby. All right, guys. Thank you for sticking with me. I know this was a long one, but it's not about just reading the indictment. We need to understand the laws and the statutes and what they want to punish her under and what she's actually looking at in accordance with what the indictment says. And the indictment says all of those things that we just went over. But let's end with our quote of the day that is fitting for this video. You don't drown by falling into the water. You only drown if you stay there. Edwin Lewis Cole. As I said, Laura Owens is drowning in felony indictments for the things that she's done to two of her victims. And she's going to continue drowning if she continues the route that she is taking. You are not drowning because you fell into this water. You are drowning because you will not get out of the water. You will not put your head above water and own up to this shit and end it. Make things better. Apologize. There's still going to be consequences for you, but you are going to continue to drown and have problems in your life if you don't change. You want to be able to breathe and get your head above water and have some of the stress taken off of you and maybe get back to healthy? You're going to need to get out. Stop staying where you're at. It's not doing you any good. You're just going deeper and deeper and deeper into that ocean that you have created for yourself. All your problems are swallowing you whole. So now is the time. It's been the time. But are you going to do anything about it? Or are you going to continue to go kicking and screaming like a toddler about this? Y'all let me know your thoughts down below. Like this video, comment, subscribe. Commenting helps the algorithm, as well as when you put a like with it, turn your notification bells on so you do not miss any other uploads. And I will see you in the next one.